5.
Okay, with the consent of other side, when I beg to mention item number 5 manner. In this case, I am going to file my counter manner. And same has been prepared and sent for petting manner.
As prayed for on behalf of the respondent. You appear for which respondent?
8 manner, registered Central Administrative Family.
As prayed for on behalf of the respondent and agreed to by the council for the petitioner. The matter is adjourned to. When do you want?
After 4 it.
It can come later on also, even later on.
27
July.
27 July.
Hello.
What's wrong?
Item number 6 to 11.
Government slip has been circulated in item numbers 9 and 10. Your Lordship. I paid for next month.
Or evening. Give a date.
28 July. 28/7. Item number 13 to 19.
Yes, on Lordship. Lordship, I beg to mention item number 14.
Louder, please. I can't hear you. Is the mic on? Yes.
I beg to mention item number 14. My 14.
Yes.
My senior counsel is out of station.
As prayed for on behalf of the petitioner. Re-notify. You're like.
23rd July.
Skip access.
May I please, Your Lordship?
Yes.
Lordship, with the consent of the other side, I beg to mention item number 19. Lordship, we have already circulated the item.
19 adjournment slip has been circulated. All right. All
Vote
right.
against.
Take the dates, please.
4/8.
Deeply obliged, Lordship.
Yes.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number 15 of the daily list, Lordship. Lordship, we have not circulated adjournment slip, but we have taken consent from the other side, Lordship.
These are merger of schools.
Lordship,
Lower primary and higher secondary schools.
Lordship, appointment.
The rules have been challenged here.
Lordship.
All right. As prayed for on behalf of the respondent and agreed to by counsel for the petitioner, the matter is adjourned to July.
July.
That may be fixed manner.
23rd July.
Mind the court, have you seen any matter being undated? That's a mandate. We always put date.
Obliged. May I please, Your Lordship? I need an accommodation in item number 17. Can
You have
please-
circulated the adjournments.
My lord, can it be on the one session?
This, I think most of the arguments were over. This is the extension being in technical wing where Mr. Mishra was making the arguments and Mr. Chaudhary also had chimed in. I don't say pitched in, I say chimed in. When do you want?
Can it be on the 25, my lord?
We keep it in June then, with no further adjournments.
After 10th June, my lord, then. After 10th June, because
Why are you busy before 10th of June?
Advocate General will be not available till 10th June.
As this is item number 17, adjournment slip has been circulated with the consent. Sometimes in June, after 10th June.
18 June. Any other request?
Wait, please, Lordship. Lordship, I beg to mention for a listing of a lead appeal, Lordship. Can it be taken on 11, Lordship?
What is the matter about?
Lordship, the regulation of service of gate for employee, Lordship.
The regularization.
Regulation.
Has it been refused? It's an
Lordship,
appeal.
Lordship, it's from the department, Lordship. They are regularizing gate 4, Lordship.
Anyway,
Want
next,
to-
next week anytime.
Yes.
Next week anytime, not necessarily Monday.
I love it.
Lordship, in tomorrow's daily list, item number 22, Lordship, then appeal has been listed, Your Lordship. We have a similar matter connected to that case, Your Lordship. That
Item number?
22 for tomorrow, Your Lord.
Tomorrow.
Tomorrow, Lordship. Can I appeal also come up along with that?
Daily list for admission item 1.
Wait, Mr. Lawson.
Yes.
Lord, on both counts, the learned single judge has heard, Lord. First of all, regarding the second,
No, you have to tell us afresh. Many a times we don't remember the facts.
my Lord, an
Coming for
advocate,
the first time.
yes, first time.
Yes, what is the matter?
My Lord, this is regarding filling up the post of assistant engineer by Karbi Anglong Autonomous Council.
Yes.
Now, there was an advertise on 17/2/17.
17 to 2017.
Yes, my Lord,
Long time back.
long time back.
Yes.
For one post of assistant engineer
Yes.
in the Karbi Anglong
Hmm.
Autonomous Council.
Hmm.
Now, eventually, my Lord, page 63, appointment orders were issued in favor of respondent number 4 and 5. Though one vacancy
No,
was
there was
advertised,
only one vacancy, no?
only one vacancy,
Yes.
but two appointments were made.
Must have been a post which was vacant.
No, my Lord.
Whether
There was a post in the cadre of superintending engineer was created post the advertisement. So, my Lord, there were promotions. So consequently, my Lord, there was a vacancy in the cadre of assistant engineer.
Yes.
That is their own admitted case in their written statement.
So
Sorry.
all right. So these respondents number 4 and 5,
Yes,
they were appointed when?
yes, they were appointed on 6/9/17.
6/9/2017.
Yes,
And when did we challenge it?
we challenged it, my Lord.
When?
We challenged it, 2018. In between, my Lord, what had happened?
You were also a participant.
I was also a participant.
Yes.
And basically, the writ petition was filed on two counts. Number one, this second vacancy could not have been filled up because that is not even an anticipated vacancy, because it accrued on account of creation of a post. Secondly, my Lord, regarding respondent number 4, he was a, my Lord, diploma holder in that AMI, basically. Now,
And what was the essential qualification?
yes,
Engineer.
that's the most important. Please come to page 52.
No, tell us first. We'll come to that.
BE Civil, no equivalent. BE Civil,
That's Bachelor of Engineering.
Bachelor of Engineering. But he is not a Bachelor of Engineering, respondent number 4. He is a holder of a diploma given by that one
AMI.
Ludhiana Institute, yes. Regarding there are a lot of controversy. Now, learned single judge, my Lord, for the purpose of buttressing the point on, my Lord, second vacancy relied upon Prem Singh. But Prem Singh, paragraph 25, Prem Singh clearly says what can be taken note of is an existing and anticipated. Future vacancy you cannot take note of.
That point we have taken and we have decided it.
In the other case, recently, yes. Secondly, my Lord, regarding that qualification part, Lanet Singh did not advert to this aspect of the matter. That,
Was
yes.
Was it pleaded?
Yes.
Was it pleaded?
Even the same, right?
Was it pleaded? Was it?
Yes, I'm coming, my Lord.
45 paragraph.
Page 45, my Lord. Yes,
Yes, for the respondents.
para 22. Must be a B from a recognized.
For Thomas Council. And no notice has
No
not.
notice has been issued.
Fine.
4 and 5 paragraph.
Take it. We have heard Mr. Kane Chaudhary, learned senior advocate for the appellant, and Mr. Shutia, learned standing counsel for KAAC. The impugned judgment passed by a learned single judge in this court is stated to be flawed for the reason of not taking into account the fact that respondent number 4, who was appointed on the post of assistant engineer pursuant to an advertisement issued on 17/2/2017, did not have the requisite BE civil degree, semicolon, rather he was only a diploma holder. The further contention of the appellant, who too was a participant, who too had participated in the interview and the recruitment process, either who had participated in the recruitment process against the same advertisement, but who could not make it, was that the advertisement described only one vacancy against which the process was initiated. So during the pendency of the recruitment process, because of promotion, one post had fallen vacant, and that place also was filled amongst the participants in such a recruitment process, which, according to the appellant, is not permissible for the reason of such post not being either existing or anticipated vacancy for which the process was initiated. Mr. Shukya, learned standing counsel, shall respond to this appeal. On the aforenoted issue, let notice also be issued to response number 4 and 5 on steps being taken by the appellant within a period of 2 weeks, both modes, returnable on 8 in the month of 8 month.
Third August.
Union of
Yeah.
India and AICT not required for the.
No. He's not, he's a diploma holder.
Huh.
Maybe AICT.
Uh-huh.
He's a diploma holder. That's your ground. We'll see that. Next time, this is the ground.
Item 2 and 3.
My lord, as per the last order, affidavit.
This is Garbhanga forest purification cancellation. Is that correct?
Yes. As per the last order,
Yes.
we were directed to file another affidavit, bringing on record the reasons for cancellation of the.
Yes, we remember.
Some instructions have been received, but those have come from the DFO allotted. This being a policy decision.
DFO would not be an appropriate.
Yes,
authority.
you would not be an appropriate authority. May I
And
pray
he
for
would
1
not,
week,
no, he would not be competent to say all this.
1 week's time, your
It has to
lordship,
be from the government,
from this, yes,
in the Department of Forests.
yes, your lordship. So 1 week's time, I'll file an affidavit from the secretary.
Mr. KP, you represent whom?
Of the forest department.
Mr. KP Patak, a learned advocate representing the Forest Department. 6. Some more time to put in the response affidavit indicating the reasons why the notification for declaring Darbhanga Wildlife Sanctuary located in the district of Kamrup Metro was cancelled. Let such an affidavit be filed by the next date, be possibly filed by the next date with a copy in advance to the council for the petitioner. This is this matter of the month of.
5-8. Item 4.
May I please, your lordship?
Yes,
Lordship, this appeal was filed against,
now we are aware of it because
yes,
we have had parlays with the sons and the father.
Lordship, my humble submission is that, Lordship, the learned maintenance tribunal was not passed the order by inserting the rezoning. The order, and that's why.
You that have a very strong reasoning. You just cannot look like this.
And India,
We tried our best to have the matter mediated between the father and the sons,
Lordship,
but your clients have not behaved well.
Lordship,
You did not go, you did not offer, you did not make an apology, you did not do anything.
Lordship,
We gave 2 occasions to you. It was not required, but considering the fact that mediation for nation is in practice mediation for nation too, we thought that this dispute between father and sons could be resolved. The father was obstinate. We did take notice of that, but then you gave him the opportunity. You provided the platform to him. You didn't do anything, and you have not been cooperative as a son, as both of you sons. You don't take care of him. His daughter takes care. So he deserves. It is a self-acquired property. He deserves that property to be let out for a better living for him, and that the law enjoins. What do? We understand. We were sympathetic to you and your wife and your children, weren't we? We came down there, we talked to the sons, we talked to the daughter, we requested her. What else do you want us to do? And not only once, twice, and we took the able services of Miss Papia Chakravarti and Roshanara, both the advocates, for getting their brief. They worked for it, but you people did not respond.
But see, we went there, but my father does not allow.
What can we do?
Yes, yes, sir.
You have created that situation. We gave you a window. We gave you a window. In the presence of the court, if you had touched his feet, you would have said something to have infused in him a sense of confidence that yes, sons will look. We could have kept it under our monitoring for about 2-3 months, and then perhaps we could have made it absolute. But we can't sort of do anything. Sorry, all our efforts went in vain, and it is only my experience on the bench has been for all these years that this was one of the few cases where I attempted mediation and it failed miserably. And the blame goes to you. You means your clients.
Not you.
The appeal is dismissed.
Deeply obliged.
We are sorry, but we are concerned with the wives and children of. So we'll do it. We'll give them time. ऐसा करते हैं. No, we don't dismiss it today. We have to just they have heard so and so. Judgment is reserved for orders on, for judgment on. You date next week. You date next week. Yeah, ठीक है. All right.
12. Deeply obliged.
Next week then.
12.
Next week last part.
Oh,
17th, 18th November.
18.
18th. Apply.
Give it to me.
We'll see what can be done in the meanwhile. There would be some way in which we can effect something. Let's see.
Lordship, I'm sorry, Lordship. This item number 5, I'm appealing for respondent number 3 and 6.
That is adjourned at the morning, Your Honor.
Item number 6.
And the affidavit is being filed, there was some delay in filing because I had to make some changes in the affidavit. So,
Which session will go then?
Milo,
Mid-session, you'll have to take admission. No? Depending on what is your view.
we are totally in terms of the 12-1C.
Is there an option?
There is no option.
That's a question.
No,
Is
only
there an option?
if your lordship recall, on the first day when I
Agreed.
appeared, your
We are-
lordship,
For the present, we are not blaming you for the reason that there could have been some confusion in the matter. This is under RTE. It was flagged in a very appropriate manner that, well, if there is no distinction between English courses, vernacular medium or that, I think you should do it. Number one. Number two, there could be some logic.
Right.
The logic would be warped in any case, but then there could be some logic. But where is the logic of your not throwing a mandate open that all the schools must register themselves with the vacancy position? Can there be any excuse?
Second opinion, no second.
No.
Only one aspect, if your lordship recall, on the first day your lordship indicated that there is a cabinet decision which was not under delay. For that, my lord, we have taken a stand that even if it is there, we have taken a specific stand in the affidavit.
We read in newspapers sometimes that henceforth, children, but this was not for this state. This was in a different state where the children of MLAs and MPs would study in government schools. And this was in the neighboring state. Sorry, this says there is no such disclosure by the state of Assam. But in the state of Bihar, there is a public pronouncement of the chief minister. I got confused. I read that news. But then you talk about that English medium. In fact, all schools should register.
Yes, well, that is why.
They can't run away from this responsibility.
They
And the schools will have to be shut down. They can't run away from this responsibility. Nobody is asking for his personal ward or candidate, a sponsored candidate to study.
Well, but then provision has to be made.
It's a constitutional mandate. We are not asking you to do that. The constitution says so.
True.
So isme don't put any impediment.
No.
You have to do it.
Right.
And in fact, the session would have begun by now.
It has lordship.
Midway, you'll have to do something because 1 year can't go.
Logically,
And these are such classes 1 to 7, huh?
1 to
Where
6.
it doesn't matter if it is the admission is taken after, but they have to keep that place vacant or make arrangement. They have to. We would like to know from you,
Alia.
what directions have you issued to all the schools? Now, please, Mr. Khatniar had shown to us an affidavit which was couched in most inappropriate terms. We did not say anything. We returned that affidavit to him. Is this the same case?
Yes, sir.
We returned that affidavit to him.
Now specific directions have been issued. Only difficulty that was there for which certain changes had to be made is that they only vernacular. It was confined only to vernacular because of the cabinet decision. But here we have taken a stand that we are going to do that also, and for that appropriate steps are taken.
And post facto approval you can take from the cabinet.
There is appropriate.
You can try this.
Right.
We understand. We are not going to blame the officers if that is the cabinet decision. But cabinet decision would have been in some kind of a vacuum. It would not have been considered. We don't question that.
Right.
But presently we are not blaming you. But there could be post facto approval of the cabinet.
That is one of them. But otherwise, we have mentioned in the affidavit,
All
we are
right.
taking steps.
Put
We will,
in your affidavit by the next week.
but affidavit is being filed today. It's ready, my lord.
Give a copy to her.
Lordship, I have a copy. I would like to make 2-3 submissions, Lordship.
Let it
At
be on
this
record, my
point,
lord. It's
we-
better than it's not on record.
This is very important.
Next week. Next week.
So we also go through the affidavit.
Yes.
You have a copy, they let them file today, receive.
Yes.
We received it at 10:30 this morning,
So
Lordship.
that's why I'm fixing it the next week.
Right.
Then in the meantime, we'll take a call on that day.
Lordship, on Friday, Lordship. If Lordship, convenient to Lordship,
Next Friday. Next Friday.
No, we can do it on Monday or 18th if you are agreeable.
18.
All right. 18.
18th of May.
My lord.
Yeah, as prayed for by Mr. Gauhati, Mr. Motion. Mr. Mazumdar, I'm sorry, I've been referring to you as Mr. Gauhati.
Not difficult.
As prayed for by Mr. D. Mazumdar. D. Mazumdar, no?
My lord.
Is that it? You're additional advocate general. Learned additional advocate general for the state of Assam. The matter is that Ghosh is there.
Your lordship is not wrong, man.
Huh?
Your lordship is not wrong.
One of the. All right.
Lordship has fixed it for 18th.
Yes.
Much obliged, Lordship.
Item 7.
Mr. Mazumdar, the difficulty with this court is that we don't refer to advocates as Mr. Counsel or Mrs. Counsel or Miss Counsel. It is always better to call them by their names. But it takes some time to register.
True.
As far as possible, I try to remember the names, but then there is some delay in giving the appearance slip. Otherwise, I would not commit mistake.
When I am bad at proper nouns, my lord. I don't remember names. Seven, my lord, pertains to promotion, my lord. Lordship had heard it at some length, but then
Yes, we
just to
have
recapitulate, my lord, briefly, this is, my lord, a promotion from the post of warrant officer to Naib Subedar. The policy in extent, my lord, prevalent.
Now,
It's,
this is the current status. Have you been promoted now?
I was promoted subsequently in 24.
But that let us not do anything about it.
My lord, if I
You
had,
lose out on 2-3 years.
my lord,
Let's not interfere.
no,
in
because
this.
I retired in 27. If I'm considered in 2020, my lord, I get a second and third promotional chance before I retire.
we can't-
Now I am losing out on both of it, my lord.
Now, difficulty is what document have you brought that it was not at your instance and not, it was.
There are
public
two
interest?
aspects, my
I
lord.
think
Of course,
that was the issue on which it was adjourned.
yes, my lord. I filed the additional affidavit.
We
now.
should have dismissed your case that time only, but we gave you the opportunity.
My lord, we
Telling
filed an
us whether it
additional
was in
affidavit.
public
There are
interest.
two aspects to it, my lord. One is that did I go on my own request?
No, you may not have gone.
I may not have
But
gone.
you continued there because of your own volition.
No, my lord. That is the affidavit that I have filed.
What is the affidavit?
In 2018, my lord, a policy came from which the respondents did not divulge. There was a policy that came, my lord, which said that in ERE duty, there cannot be a second tenure unless and until there is a special recommendation of the commandant. So, Annexer A7, page 103, my lord, I have filed a letter that there were specific directions given back to revert back everybody immediately.
Yes,
Had I been reverted 107, 103, my lord, in my additional affidavit. Had I been reverted back in time, my lord, I would have earned my second ACR from the unit, which I could not do because I had to stay one more year because they did not send me back. 93. Beginning from, my lord, phase 18. Annexer A7 in page 103, it is 8 January 2019. There are letters before that also, but then 8 January, because I had to come back in December 2018. This is pertinent, my lord.
Your numbering is slightly difficult. Give us the number of the, I mean, you have the running page number or the.
103, my lord. Should be 103.
10?
103. The additional affidavit starts from page 88.
10, that number has been struck off. This, I think, is something else.
I think, is it a letter of July 2015, 17 July?
No additional affidavit, my lord. Initially, we numbered it from page 99. The
that's
office
fine.
corrected it as page 88.
There are-
So the last page of the same.
Additional affidavit filed on 19/2.
No, my lord. This was
19 February additional accrual.
February, my lord.
19 February.
82 is 19 February.
19 February. I heard Zoom, my lord.
No, there are two annexes to your additional affidavit. One is dated
No, there are 7 annexes, my lord.
17 July.
No additional affidavit in February 2026, my lord. It has 7 annexes, my lord. Initially, we numbered it as page 99. Office corrected it as page 88. So the running page number now would be 103, which is the last case block.
Ninth May 2018.
A5 is 5 March 2018, then 29 March 2018, and then the last annexer is 8 January 2019. Page 103.
Some different documents are annexed. Last page is 29th May 2018.
No, Lordship is probably referring to the earlier affidavit, my lord. Page 98.
The ROI of one of ROI. There cannot be a second hearing tenure before completion of schooling of period of 3 years. The appellant begs to state, I think this is an issue 5, 6, and 7. Let's see. 6.
The annexer 5 is on page 101.
101.
10101. Next one.
So this is the concern ROI, my lord. We could get a copy only
Alright,
after
alright.
filing of the.
Mr. Chakravarti, Lordship, how do you respond to this?
Lordship,
So therefore, even if Mr. Patak would have made a request for his overstay on ERE, this letter would prevent it. So therefore, it has to be presumed.
This letter is based on this policy.
Lordship, may kindly come to page 37. Page 37, Lordship,
37 of the brief.
or the rate appeal, Lordship.
But what do you want to say?
While rejecting his case, Lordship, we clearly stated you came to here at your own request. This communication has not been challenged. Neither has been disputed. That is on the basis of this, the single judge, honorable single judge has allowed the writ petition,
That is
Lordship.
single judge
Now,
said.
if he said that,
Could you have done that?
Lordship, he was.
You show us the letter.
Lordship,
You show us the letter, you show us any communication, you make a statement that this was, which officer will testify that he had come off his own? Because see, look at this. Now, turnover of ERE persons, there is a mandate that you should think of a reliever beforehand so that he doesn't stay on a ERE duty for more than 3 years. And it can come back to him again after a cooling off of 3 years. So he would have earned.
Lordship, page
Perhaps
46.
he was happy at that place. Now that he has lost out on his promotion.
Lordship,
he's
page
thinking that-
46, page
Huh?
46.
What page 46? You tell us.
Our affidavit, Lordship, we have stated so.
Page 46.
The 11th line from top, Lordship. May I read, Lordship? The petitioner never made any request, nor ever he submitted any written representation requesting for his reversion to
This is
parent.
something else, no?
He enjoyed, Lordship.
He rather remained silent when his field unit 31 was then posted.
There in the field, Lordship, at Chasar, in Manipur, a hostile territory, and he was enjoying his soft posting at Shillong.
No. This is completely wrong, my lord.
Have you disputed? have you
ERE field
disputed
intelligence posting is always on ground. Shillong is the head station, my lord. I'm always on the ground. That is the very function of an intelligence officer. And that part I had disputed in my lord, para 7 and 8. Repetition I had stated so.
What is your explanation, Mr. Pathak, on this 48,
My lord,
47?
my repetition, my pleading is that I have my
No
lord,
rejoinder.
continually asked the commandant to send the reliever.
no
It
rejoinder?
was not done. At that particular point of time, I could not get hold of these documents. When this court gave the opportunity, I could collect these documents in my document.
The single
You are in Manipur at that point of time, has this.
unit was
No,
in Manipur.
my parent unit was at Manipur. Then
You are in
Shillong, yes.
no, my posting, my lord, the headquarters of the field intelligence unit is at Shillong, but then my posting was in various places, my lord.
But suppose somebody does, Mr. Chakravarti, this is a question to you. Somebody keeps quiet. Would you allow him to remain at that place?
Lordship,
Against the policy.
we have explained, Lordship, generally at field extra regimental engagement are done at his own request. That was stated in our affidavit. No written order is passed. Only, Lordship, a movement order is issued. That will, Lordship, find page
But
annexure 8.
you went beyond,
Clear.
you went beyond your mandate and not relieving him, no? That's what he says.
No, he could have asked for,
Therefore,
he was
there is no
enjoying the,
affidavit before us.
he was
except
enjoying the
oral
soft
discussions.
posting. He was enjoying the soft posting, Lordship. And how honorable single judge has dealt with that aspect, Lordship. Kindly see, Lordship. Even Lordship is two views is possible, Lordship. The view expressed by the honorable single judge has to be, unless there is a compelling circumstances for that, Lordship.
This is a very stock argument that you are making. This we employ, you're not supposed to remind us.
Lordship.
We can always say that this view is incorrect and therefore we are taking as.
Lordship, paragraph 7 of the judgment, page 68.
Paragraph 7.
Page 68.
You had, Mr. Pathak, did you make any written application for your return?
No, my lord. No. I only, the procedure is, my lord, they don't entertain this kind of activity. I only requested the commandant. The commandant says that it is under process.
That you needed the 2 out of the 4 ACRs to be of the field duty and not ERE.
Not yet.
Correct. So you should have made a request. How do we dispute this then?
Because at that point of time, my lord, again, the Meghalaya High Court judgment that we relied upon, Meghalaya High Court had already said that ERE duty is also part of the same organization, so it cannot be discarded.
Beyond our reach. We don't enter into domains which are not meant for us.
My lord.
We never enter into that field. Though it's not something where eagles can't dare, but then we don't get into, we know our Lakshman Rekha.
My lord. So essentially, he followed that particular verdict, my lord. That was the prevalent practice that happened, my lord.
We get an impression that you are happy at Shillong.
No,
You are
my lord,
absolutely happy at Shillong.
Field intelligence unit is, my lord.
See that you would get through.
Field intelligence is the most difficult job, my lord, that can be done.
By that time, you were aware of the Shillong judgment,
My lord.
Meghalaya judgment. So you are happy, content.
No, but then also, my lord, as far as,
Manipur. Now you want promotion also.
my lord, the ROI, my lord, which is not.
Mr. Pathak, those are in lighter weight. What do we do when there is an oath? When there is nothing on record? Statement made by your employer under oath that no request was made. You could have just written a letter. Let them not entertain. You could have said that, no, I want my field duty. This is ERE. I'm not always interested. Maybe in the first instance, it was at your request. Turning it down only for the reason of this letter where maximum period is 3 years, but they were indulgent to you and you did not realize that at times these benedictions can go against the person. When are you slated to retire?
2027.
We are not getting persuaded.
I would have got a chance to become a Subedar, my lord, had I been promoted in 2020. My lord. That is okay. And as far as ERE duty is concerned, it's not a soft posting. You also could see the ROI. ROI has specific requirements. Only specialists can be actually posted in this intelligence.
Instances of people foregoing their promotion for a soft cushioning seat is not unknown.
Yes, ma'am.
It is not
It's not
unknown.
unknown. There are, my lord, the policies also and rules also which says that if I make a request transfer, I forgo my seniority also.
Please no written letter. Had there been one written request that please send a reliever, we would not have done anything except allowing your claim. And in that case, you would not have even gone on the judgment of the Meghalaya High Court, which read down that requirement. Yeah. Sorry.
But at best, my lord, I can only show these documents that my department itself was pursuing, but then somehow they were not relieving me. It is not my fault that I could not go back. I could not have gone back on my own volition.
It's good for argument. On the, in the first blush, it appears to be attractive, but there is no written requirement.
There's no written request.
There is no written request. And you knew about it.
Only verbal request, my lord,
Then
which I also have stated in
we-
it.
Would we be failing in our duty in not presuming that you are aware of the Meghalaya judgment and you wanted one more year of soft posting?
No, the post
Not
was
only-
not stopped, my lord. That time, my lord, the contest as far as their submission is concerned. Intelligence unit, my lord, is the most difficult posting, my lord. I have to be in field without arms here.
Take them. We have heard Mr. B. Patak, learned counsel for the appellant, and Mr. B. Chakravarti, learned CGC. The challenge in the present week is to the judgment dated so and so passed by a learned single judge of this court in WPC number 4336 of 2020, by which no interference was made in the decision of the respondents in not granting promotion to the appellant on account of there being no two mandatory ACRs from the field unit. The appellant, next paragraph, the appellant, a senior warrant officer of Assam Rifles, that Assam Rifles contends that he was sent on ERE, bracket extra regimental employment duty, for 3 years, from November 2015 to December 2019.
3 years is till 2018.
From November 2015 to
November 2018.
2018, in public interest by his parent unit, namely 31st Assam Rifles. However, he remained in that position for 4 years, not out of any choice of the appellant, but because no reliever was sent to relieve him of that assignment for him to join the field/battalion duty. Though the appellant contends, though the appellant claims that he desired to return to his parent unit, which could not happen only because of no reliever being sent in his place. But the fact of the matter is that there is nothing on record which would indicate that any written request was made by him for joining joining the field/battalion duty. This was required because the recruitment and promotion instructions, bracket ROI number 4 of 2022, as amended in 2013, requires that for promotion, an officer in 5 years must have at least 2 ACRs from a field battalion or a specified unit. By the time the appellant joined the field duty, 4 years had already passed, and therefore he did not have 2 ACRs from a field battalion or a specified unit. which precisely was the reason for denying promotion to him. The contention raised on behalf of the appellant before the learned single judge was that the ROI 4 of 2002 as amended in 2013 requiring 2 of the 5 ACRs to be from field battalion or specified units is not mandatory, and such instructions do not have any statutory force. So in that case, relying on such instructions, the promotional avenues of an officer, and in this case the appellant, could not have been marred. It was further urged on his behalf before the learned single judge that as a matter of fact, the appellant being a disciplined member of the force could not have done anything otherwise than obeying the orders of his parent field unit of remaining posted at a place under the extra regimental duty. He has also argued, it was also argued that in the case of the appellant, the ROI ought to have been read down for the reason of the appellant having remained on ERE without his specific demand. On the contrary, Mr. Chakravarti, learned CGC, contended before the learned single judge as also before this court that the ERE posting of the appellant was on his own choice and request and not in public interest. Had he specifically wanted to come back to the unit or to any field duty, such request would have been made. In fact, Mr. Chakravarti alludes that the field posting would have been in Manipur, which was a difficult assignment as compared to ERE duty in Shillong. True it is, as it appears from the records, that there is no written request or written request from the respondent, from the appellant, for his return to the parent unit or any formal order of the parent unit of asking him to join the parent unit from his ERE duty. But the fact that he remained on the extra regimental duty beyond 3 years was against the instructions in that regard. The Mr. Pathak, counsel for the appellant, has drawn the attention of this court to the Assam Rifles Record Office instructions for ERE posting of personnel, which imposes an obligation on the employer that imposes an obligation on the employer that there should be timely dispatch of reliever and that no personnel on ERE ought to be withheld for more than 4 days of the reporting of their reliever. So in case reversion is not carried out even after 30 days of reporting of the relief, unilateral suo motu movement orders will be issued by the date. This condition, Mr. Chakravarti explains, is with respect to a fact situation where a reliever is dispatched, but the personnel in the ERE does not come back to the parent unit. Under such circumstances, after 4 days of the reliever having been sent, there would be suo motu movement order. The facts of this case, the facts of the case of the appellant is different. There is no reliever sent after the completion of 3 years of ERE assignment of the appellant, and no written request whatsoever of the appellant of being repatriated to his parent unit. In that case, there could be a presumption, and a valid one, that the appellant remained at Shillong under ERE of his own choice, which ultimately came to his disadvantage, because by the time he joined the field duty / battalion duty, he had already lost out on one of the ACRs being from the field duty at the time of promotion. The learned single judge, taking into account the aforenoted facts, refused to interfere with the denial of promotion to the appellant on that ground. And we find no strong reason to upset such a finding of the learned single judge. More so in the background of the stark paucity of any request having been made by the respondent, by the appellant, for being relieved from the ERE at the earliest. Thus, without adverting to the other reasons and without interfering with the observation made by the learned single judge, which is in the nature of a suggestion in matters of posting of the personnel on such ERE, we dismiss this appeal, but without any order as to process.
Item 8.
Yes, Mr. Dasgupta.
Yes, no, last edition, your lordship.
We asked you to inform us whether your clients have retired or not.
Yes, yes, only respondent number 1 and 10 has retired.
And how many of them? So minus 1 and 10. And if there are only 10, then it remains 8. Here then, but why do we insist for refund? Why do we insist for refund? It shall be refunded to you in case others also they will have to do it. Why to undertake this process of first refund, then inquiry?
No, on the contrary, after imposing penalty, you are holding inquiry.
वो तो आपने challenge किया नहीं है. That is not your challenge now. That is not his challenge now. That is not your case also here. आप अपना case करिए. You could have done that.
In my case, it was specifically stated.
What amount will have to be refunded, Mr. Speaker?
My lord, my submission lordship give
What
me,
amount will be required to be refunded?
that has to be ascertained, my lord, that has to be ascertained.
See, there has to be some parity amongst people.
The huge amount, my lord.
Individual.
Individual, I can-
Less than hundreds of level.
200.
200.
200.
What is the individual amount?
Individual amount would be, you know, for more than 45,000, like that. No, it will be,
No, I don't know.
45,000 each.
No,
but no, it may be,
not.
it differs, my lord.
45,000 per month.
No.
Yes, you see.
Yeah.
10,000.
Big number.
10,000 पे तो कटा होती थी.
Huh?
10,000.
More than 1 lakh, 2 lakh.
I can give you lordship, my lord, with the lordship. So, my lord, my submission is lordship may give us, my lord, definite time frame, my lord. My lord, when they can wait for 1 year, my lord, they can wait for one and a half.
No, that is
We'll complete the process and then.
Mr. Speaker, Roy, he could have taken a different view. And we are inclined.
No, yeah, I understand. I fully agree, lord. And your lordship has already,
Please hear us out.
lordship.
Now, all blame should go to your officers and not these laborers.
I-
The certification was not done by them.
Yeah.
They may have colluded. They may have been happier receiving money which they did not, but nothing comes for free. No breakfast and lunches are free.
Lord.
If he would have been paid, that money would have been extracted by your officers. That out of 5,000 rupees extra payments, give us 3,000, you keep only 2,000. These poor people, they would have been happier. Right? I'm absolutely sure about it. Your officers would have extracted all share from it.
Just might be.
Personally, well, honestly speaking, I cannot disagree, my lord. It has to be, my lord. It has to be. But not.
They are the medium
That's
for your collection.
That's
That's all.
Okay, they are poor persons. Return.
only, my lord, no, my lord, it will be little onerous on us, my lord. That your lordship has indicated.
You have found. Where have you dismissed your officer? What action have you taken?
Yes, no,
Then
Hmm.
can you come here and say all this?
This is only for the purpose of recovery. No punishment to your.
No punishment to them, they are not at fault. You pay them now, you want them back. 2 persons have retired, they're laborers. Refund them. See, normally we don't take any sides, whether the party is big or party is small. But here, the heart would bleed. Of course, we have recorded our observation.
My lord,
That there is-
monthly, they get more than 1 lakh. That is the including an incentive.
आपका officer को कितना मिलता है? Who certifies, what does he get? And I'm sure this may not be taken in a serious note. The FCI would be a bigger paymaster than Mr. Das Gupta's clients.
I'm not sure, my lord, what action they have taken against my
No,
officer.
then return that. Return that amount. You don't press, otherwise we'll make it a general rule.
But
Take instructions, at least
Problem-
to 8 of them, or at least to 10 of them, return the amount. Return the amount.
There is one
In
difficulty.
fact, we will not even insist for any recovery anytime, whatever happens.
There also. But my lord, in respect of other employees, we have initiated the process.
You may have.
There are other petitions who are already passed an order.
You may return that amount. Because others you refunded for initiating an inquiry. Or forget about inquiry against them.
So we made inquiries in respect of others and passed the order of recovery.
Any findings? How?
Yes.
was, such huge amount was transferred to laborers
Yes, in respect of
fault?
others, recovery is already made.
for whose fault?
And recoveries have been made.
Yes, sir.
Give us few instances.
Oh, there is filed a writ petition also against that.
No, give us, they have filed writ petition.
Oh, my lord, I can give your lordship the case numbers. Read.
What has happened in any idea about that writ petition?
My lord, there were three writ petitions altogether filed by 137 laborers challenging the same order. In respect of others, the honorable court has given us liberty to hold inquiry. We held inquiry.
That we are not saying. Whether
Ask
that,
something else.
that inquiry completed or any recovery is made thereafter.
Yes, made.
When?
But the recovery is already made long back. We only upheld that order earlier on.
But how many in how many cases did you refund that amount for starting the inquiry?
No, not again. Before no, nobody. Before starting inquiry, we have not.
You have not refunded.
No, my lord, they already recovered it long back. Soon after the order passed, recovered it. But it's only after that.
Recovering, they have initiated this inquiry.
Recovery has been made, my lord. And
For all
only
this
after
process.
that, all right, lordship is, lordship may, we can also, if the inquiry finds that they are not guilty, they will get money. And if the inquiry, after the inquiry, it is, they are found to be guilty, we'll make an inquiry back for refund.
We don't wish to change that. That's the view of a single judge. We will not, even if it is. And they're in service. You will stop making them payment if they do.
Yes, sir.
Only two of them
But
retired.
for two of them, my lord,
Retired persons also, they need to be given that money. Otherwise, you can't recover, even if they are at fault. You can't recover.
so your lordship has indicated the last order.
We will change.
Lordship-
We'll change that. We'll say that on that day we thought it differently, but after Mr.
But,
Das
no,
argued the case,
It
we
will be
made a
difficult
different.
because the laborers are not from Bihar, they come from Bihar, it will be, or not from Nepal, I do not know.
No, most
It
of
will be
them are
difficult.
from Bihar.
It will be difficult, my lord.
I have interactions. 99%.
They are
From
under
Bihar.
their roles.
So, my lord, it may be difficult for us, my lord, to make it. That is the only,
And they have settled
your
here.
lordship has appreciated my submission on the last occasion. That
We have, that is, we have recorded your submission. We have not given our imprimatur on your submission. But today we find that when you have done it for others, they are in service. It will not be difficult. Refund that amount.
Yes.
And we are asking only for these respondents. Only asking for these.
others are, my lord,
Others we are not touching. So we do one thing.
lordship.
Others will come running.
That's why, that's how.
So therefore, withdraw this appeal, make payment. Make payment on the next day, say that we are not pressing it for the. That's better. Take instructions. We understand your difficulty also. You're a public body. You're a public sector enterprise. Don't take our orders. So what you do is this.
The lordship may kindly indicate in the order, my lord. That's right. Otherwise it will be difficult for them, my lord, to.
We will can indicate. How can we indicate that, well, this will be only for these persons, and in order to avoid other persons coming to the court, we are asking them.
No, others are not before lordship.
Do the appeal. Can we do that?
No, others are not before lordship. My lord. Only.
Then the better option is to
Or
dismiss
my
it.
lord, lordship may give us, that's why I'm submitting, my lord, in 1 month's time, we'll complete the process, they'll get, my lord, if they're not. We'll complete the process of inquiry and pass it out order.
1 month's time or
That way we are staying that part of the judgment of the learned single judge which is under challenge. No.
the
We are not getting persuaded, Mr. आप अपने ऑफिसर को डिसमिस किए रहते, perhaps we would have agreed. That certifying officer, he should be made to pay through his nose. Not these workers. They lift bags on their bodies. And you would not have allowed them to pocket that amount, I'm very sure. You would have shown it in their names. You would have taken it all in your kitty. उसको आपने, you have not dismissed any one of them. You have not done anything.
well, I'm not sure. I don't.
The top man of FCI ought to be punished because of not taking action against the certifying officer. इनसे आप पैसा रिटर्न करेंगे ऐसा. We will also not ask you to. We will. I mean, foreclose it even if you decide otherwise, and if they come.
Well, Lordship has indicated, Lordship will adjourn the matter for Lordship give me some time. I'll personally I'll write to them, indicating.
You have not initiated any departmental proceeding against them.
So far as them, because of the order passed by the Secretary. They said you make
They should take a court. Drop the proceedings against
it is only because of that.
that way we can grant you adjournment. But don't initiate. The order is in force. We have not stayed that order. Have we? Have we stayed the order?
No. The Lordship has rightly said, it will grant me some time. I'll ask them to make report.
Why do you want to make that? I mean, we said that, but let us discuss this petition. You do whatever you do. Let's close it.
Or may not.
We will record every submission of yours.
No, may not.
We'll be very, very careful in recording all yours.
Lordship will grant me time. I may also withdraw the appeal. I'll let them start.
You may think of withdrawing it.
I may, that would be better without.
Because only these 10 you'll have to refund and then.
Yes, yes. That would be.
Others may not
Yes,
question. Mr. Dasgupta, this way, the snake would be killed and the lathi would not break. Correct?
No, matter so far we are concerned, all the amounts have already been recovered from our salary.
आपकी recovery हो गई है?
Oh.
Then you withdraw. If you have recovered everything from them, then you withdraw.
No, but we cannot initiate the process. That is.
Sorry.
Now, they have recovered, but the learned single judge
Therefore, you
held that you cannot
withdraw
do
this and comply with
and
the.
this order was
order and
That's why
proceed.
I was submitting.
We are
Can't be
granting
time, not do that.
weeks. We
4
are
weeks.
granting you 4 weeks.
4 weeks.
Withdraw this, I mean, refund their money, do whatever you wish to, initiate proceeding for recovery, and withdraw this appeal so that it does not, our orders do not pave way for others.
I'll instruct them comply with the judgment and inform you.
It's a better option for your benefit. Otherwise, there will be 400 persons coming in.
My apprehension was on that one.
As prayed for by Mr. P.K. Roy, Learned Senior Advocate for the Food Corporation of India and others, and agreed to by Mr. Dasgupta. Agreed to by Mr. Dasgupta, Learned Senior Advocate representing the respondents. The matter is adjourned to after 4 weeks. But within that period, you come. 4 weeks only.
11 June.
Or you can make a mention for revision.
Item 11 and 12 for hearing.
Yes, Mr. Boyd.
First of all, my lord,
Huh?
I express my gratitude to this honorable court so that I can fulfill one of my
No.
dreams.
All these, this is well deserved. Well deserved. Well
I'm
deserved.
obliged for that.
We will, but we'll be getting up now. There is an urgent meeting.
My lord,
We'll resume only at 2.
my lord,
So we will hear this appeal today.
my lord. There's a report also has come in with regard to authentication case 20 to 25. And if that upper limit is been considered, on the date of occurrence, it happens to
We'll
be a
see.
minor.
Yes. We'll see and thereafter we will.
Yes.
But we resume at 2. There is a meeting
Yes, so we'll come back at the meet at 2.
at 2 o'clock. Any difficulty? Otherwise we can.
No difficulty.
Lordship, item number 16, I could not mention in the morning, Your Lordship.
Item number?
16, Your Lordship, I had the consent of the other side, both the department and the appellant, Your Lordship.
16.
16, Your.
Yes.
Kindly adjourn, Lordship, kindly adjourn, Your Lordship.
Item number 16, you appear for the appellant
No, Your respondent 1, Your
and
Lordship.
you have informed.
Yes.
No, this was
with
already
consent.
adjourned, isn't it?
None.
No, 16.
Huh?
None.
As, what is your name?
A. Goswami,
Mr. A. Goswami, learned counsel for the respondent.
number 1.
Respondent number 1, after having obtained consent from the counsel for the appellant, makes a request for an adjournment of this case. The request is exceeded. Let this appeal be listed on sometimes in June, July.
21st July, 21/7.
I think we are left with only
13 and 18.
13.
So what we do is this, we'll start hearing you at 3 o'clock. We'll first do item number 13. And then after item number 18, we finish that and we start hearing.
So we'll meet at 3. So for our cases.
Please keep one junior here in case.
Yes, sir.
in
Sure,
case
Those adjourned.
Those are adjourned, then we straight away come to you.
Sure, definitely.
Yes.
Item 13,
Yes.
Am I audible, my lords?
Yes, you're audible and you're visible as well.
My lords, I'm sorry, additional affidavit which will be filing, will be filing today itself, my lord. So if a shortly may be given, my lords.
What affidavit? You have argued your case entirely. What else are you going to
My
file?
lords, have directed me to file my lords have directed me in the last occasion to file the sworn affidavit. So we'll be filing this through an additional affidavit, my lords.
With respect to your brother. Anyway, when would you file
Yes,
it?
my lords.
When do you want to file it?
My lords will be filing it during the course of the day, my lords.
Very well.
Today itself, my lords.
Then we keep it next week.
My lords. I believe my colleagues are filing it as we're speaking, my lords.
At the request of the learned counsel for the appellant, the matter is adjourned to next week. Next Tuesday.
Obliged, my lords.
12/6, 12/5. Item 18,
adjourned.
Yes, who appears for the petitioner? It's your case, come. It's Mr. Nan. Mr. Das, you have made some research. With respect to railway pension rules, there are two judgments which we have indicated in our order, earlier order. I think it's Karnataka and I don't know which. Karnataka and Mumbai. Widows. I think that is legal. That is legal. That is only legally correct. Muslim employees who may have two widows, three widows. I mean more than one. Polygamy. Polygamy there. How about children? No, children have to get no even from the second wife. All right. All right. I think we also were of the same view. So this can always be read like that. Then in that case, that day we did not pass an order only for the reason that there are many others who are getting pension now. With this judgment of ours, it shall be stopped. So those videos are for people where polygamy is permissible. Mr. Nath, you are aware of that judgment? Can you pass on that note to us? Then don't go by memory. Otherwise, give him a copy of the judgment. I think that's the only legal view which I can think of. Which judgment talks about this?
Mr. Das, in which judgment both earlier judgments are discussed and interpreted?
One. Just read it aloud. Yes, yes. And then the matter traveled to full bench also decided the same. Correct. Thank you, Mr. Das. Yes, what do you have to say? Yes, Mr. Nath. Even otherwise, we go by whether we are not concerned with that, a full bench of High Court, and otherwise, this is the only explanation which appeals to us. Really go by this. It's 2020, 2020, volume 5. Do you want to say anything to this or do we conclude? Hmm? Who appears for respond number 5? And which provision talks about the minor son born out of the first child born out of the second wife? And what is the share of the allocation? We can use that word proportional. We do one thing, we'll not keep it pending, Mr. Nath. You have a look at the judgment, and then we put it on Friday or Monday. Give your time, we post it for judgment. Whatever you have to say, you can say that. We'll dictate in your presence, but then you take time and find out. I mean, there is no other way in which we can think. Yes, Mr. Yeah. That also has been taken note of in the judgment cited by Mr. Das. So therefore, this rule is applicable only so far as communities where second marriage is permissible and they're not governed by Hindu Marriage Act. Okay. और कुछ देखना है या खत्म करें इसको? You want to say something or we will conclude this and we dictate now? tomorrow. आप देख लीजिए इसको, we'll post it for orders tomorrow. All right? Arguments heard. Take the name of the party. Post this for judgment tomorrow. Tomorrow मतलब? Yeah. I'll do that. At 2 p.m. At 2 p.m.
Item 11 and 12.
Thank you, Mr. Das. We wanted this judgment as a support.
रिपोर्ट फाइल में हाँ Xerox only.
I don't think the prayer made by him. That doesn't apply, no? He was a major. On the date of examination, he was.
Next page.
Let me see the original report.